Okay, abusuya ba makwa ba sonko so edeba POG Media so. Abusuya yembonra yensem. Majority leader ede ensem bi aba betudwa about the removal of Chief Justice Torkonoo. Na aba be blast na just what throw ni support to 5 members committee and as John Dramani Mahama say the petition 3 petition na nsa kan no omo investigations about it. Now Nensema odi tudwa no or kire say Chief Justice Torkonoo say or accept bibi bia Up&Face or 3 members committee ni so na sa ne the oya or kire say opese bibia in camera bibia fair omoma obia enhu the investigations no the no masa constitution no enye sa ne wo na enka ompese sa de no krampo ebisi a enka time a oba ya ye as chief justice no enka omo anyede omo yi no as chief justice krampo into ono no ontena se na face bibia na onjai se the piano or the neoma ekopi mu court or court back and forth no or accept any seni or enjoy sa chief justice rule no into consequences be aba say or sanso a face momi yanko na yankonkuti majority leader in parliament Mahama Ayariga&NDC or the tuja medamase.
This quickly developing story once again came up in Parliament, where Majority Leader Mahama Ayariga is now asking the suspended Chief Justice to just accept the procedure to remove her from office. And again, some interesting points being made.
Anybody specifically say that this part of the process is not provided for in the Constitution? Somebody says, I want the hearing to be held in public. I want a transparent process. Did the Constitution say a transparent process? Did the Constitution say a process in camera? If the Constitution said a process in camera, when you are being vetted in this Parliament and you are being appointed as the Chief Justice, why didn't you say that I am accepting the job subject to me not accepting the procedure for removing me? If you had told us at that time, would we have appointed you as Chief Justice? It comes as a package. You cannot accept to enjoy the perks of the office of Chief Justice, and then the procedure by which you will be removed, you say that you not accept that one. Where were you when you were being appointed Chief Justice?
I remember we also spoke about the Majority Leader yesterday when he made very bold pronouncements on the floor of Parliament regarding the desire of the current administration to make the removal processes smoother, backed by legislation. Today, he appears to give more clarity and substance to what he has said. Because again, remember, we had the conversation about a counterproductive position with the Majority Leader's comments yesterday. Today appears to give more clarity to what we heard yesterday from him on the floor of Parliament, and we can now turn attention to other matters. Because tonight, many questions are being asked about Chair. It brings us the very latest, a total look at the chronology of events that took place in court earlier today. Dennis, talk to us. We have seen interlocutory injunction application, one after the other, a total of 5 at this point. Today is the first one that the Chief Justice herself appeared in court in person for, because her name also appeared on that document. Talk to us about how events played out in court today.
Well, so today actually, like you rightly indicated, is the 5th time we are seeing an interlocutory application before the Supreme Court, all geared towards stopping the processes that are ongoing, seeking the removal of the Chief Justice. This particular one is a bit different because in there, you have the Chief Justice herself now being a plaintiff applicant in this particular matter. However, the outcome is not any different from the others that have come before, except to say in this particular one, the ruling of the court has been a unanimous decision. In the 2 that came before this one, the ruling of the court was a 4-1 majority decision. They dismissed that. The first one that came before the court was a 3-2 And today's, like I mentioned earlier, was a unanimous decision by the court. But in order to put things into perspective, Kemini, let's begin to look at what actually transpired in court today. Quite a number of things to observe. That for the first time for many, they saw the Chief Justice herself come into the courtroom from a different place altogether. Because on a normal day, she would have come through the chambers to the bench. So like walking from her backside, the backside of where they sit in there. But today, she used the part where everybody uses. Like you and I go into the courts, we use that into the courts.
I can imagine how strangely that must have felt for her.
Yes, and it was quite, strange, like you say. But those who were there understand the circumstances. And also, even with the sitting arrangements, ideally, she would be on the bench. So there's the bench, there's the bar, and there's a place where parties sit behind the bar. So she was behind the bar to say that, okay, I have a case, I am here, just like you and I would. So that was quite a special observation to be made for today's proceedings. But beyond that, even before they could get into the substantive matter, because the business for today actually was for the hearing of the injunction application that the Chief Justice is seeking to stop the process. She raises quite a number of issues, praying that the process as it is going against her should be halted because she complained about quite a number of violations. But the preliminary matters that had to be determined before they got into that substantive issue was one, an issue that was raised by the Attorney General, who was represented by the Deputy Attorney General, the learned Dr. Justice Rimsai. He was praying the court to exclude from the suit the 5 members of the committee who are probing the petitions that are seeking the Chief Justice removal. And just to put that into context, so this is how the respondents look like. So you have the Attorney General as the first respondent, and then following that are the 5 members of the committee sued in that order. So the Attorney General's argument was that take out these 5 people, let it be just the Chief Justice as the plaintiff applicant, and the Attorney General will be the defendant respondent.
What was the reason for that?
So his reason was simple, that on the face of the writ, you would find that the Chief Justice makes the point that persons to be affected, in one of the paragraphs that have been stated in there, to be affected in the suit would be the Attorney General. According to the Attorney General or the Deputy Attorney General's argument, it didn't say more. So in his view, if the only person who is going to be affected by the suit is going to be the Attorney General, then why do we have this? He also makes the case that these people, their specific addresses had not been provided for on the face of the writ. However, that was opposed strongly by the former Attorney General, Godfrey Addo, who is the lawyer for the plaintiff in this particular matter. That's the Chief Justice. His argument was simple, that when you're looking at whether somebody is a proper party to a suit or not, it's not just about naming the person or mentioning the person, but as long as claims or reliefs are sought against those persons, they are proper parties. And he did indicate that when you look at the writ and the reliefs that they seek, as many as 6 of them are against members of the committee. And to that extent, they are proper parties. They should be a part of the suit. This found favor with the court, and the court overruled that objection that was raised by the Deputy Attorney General. Just when that was cleared, you recall yesterday on this show, we did indicate that the Attorney General had filed a notice of legal objection to the effect that he wanted to exclude from the processes a supplementary affidavit that was filed by the Chief Justice. In there were some depositions that were made or statements that were made which have something to do with the in-camera proceedings that are ongoing. It was the Attorney General's view that those depositions or those statements are supposed to be protected by the Constitution under Article 1468, which requires that such proceedings be confidential. And to that extent, it was not proper for them to be brought before the courts. The former Attorney General opposed to that. His argument or counter-argument was that, in his view, what amounts to proceedings is different from what they are complaining about. And that, in his view, the proceedings will include the petitions and the actual hearings. But what they are complaining about, including the searches and all, in his view, are not proceedings. He also says that if the argument of the Attorney General is to be upheld, what it means is that even if there is an overstep of some of the actions of the committee members, it means that you will not have the right to even challenge that decision because the question of confidentiality will come up. So he thinks that the supplementary affidavit was necessary and it ought to be part of the processes. The court had to take a decision on that. They came, and this particular legal objection by the Attorney General was upheld. That is to say, the affidavit, the supplementary affidavit, was struck out of the process.
And will no longer be part of the case. But,
not at all,
you know,
yes.
I'm just wondering, right, because in that application that the Chief Justice had made or so, it wasn't just about the in-camera issue. She had also raised issues about mental torture and how, you know, the location for the exercise itself was changed and it was meant to somewhat intimidate her. Now, by this ruling, how do we translate that in English as per what she wrote in those applications?
So like I tried to explain, there was an attempt to explain what amounted to proceedings. Now, when you even look at the supplementary affidavit itself, it did state that these were matters that arose as a result of her appearance before the committee. So that in itself, I mean, that was the view of the court. That in itself created a sense that it was part of the hearing of the committee that those matters came up. Indeed, the former Attorney General made a point that when you look at the affidavit, he says that from paragraphs 1 to 6 were not matters within the proceedings. But when they read it to him and asked if these matters did not only come after she went for that hearing, I mean, it was difficult to justify. So on that score, they deemed those matters to be matters that arose from the proceedings, which is supposed to be in camera, and that the sanctity of the process needs to be protected under Article 1468, and to that extent, it should not be part of the record.
Which means that out of the Supreme Court ruling that we have today, all those things, the allegations, the concerns that the suspended Chief Justice held will not show up anywhere in the case as it's being heard.
Okay, so mind you, the supplementary affidavit in support was for the application for interlocutory injunction.
Only?
Yes. So what it meant is that if the court is considering all the facts before it, it will not consider any fact that was included in that supplementary affidavit. In fact, the court had reason to tell the lawyer for the Chief Justice, that's the former Attorney General, that he could have actually prosecuted his case without that supplementary affidavit. And that their view is that it is matters within the proceedings before the committee.
I mean, speaking of the former Attorney General, Godfred Dame,
yes,
we know that he also expressed misgivings about how the case turned out today in the Supreme Court. He thought it was violations of the rights of, the occupant of the highest office in the judiciary. I want us to take a listen to Godfred Dame at this point because we'll come back to Dennis. Dennis will share with us what the next process is. Because remember that we'll bring you that video clip in a bit. But Dennis, remember also that these are only interlocutory applications.
In fact, preliminary, even before the interlocutory injunction itself could be heard. Even in fact, there was a third one, and that was raised by the former Attorney General, the learned Godfred Dame. His argument was that, his objection was the AG's representation of the 5 committee members. His argument simply was that as an Attorney General, you are basically the legal advisor to the government to represent government officials and all that. He was wondering why it was the Attorney General who was representing the justices, Daniel Yaodemolevu and the Major Flora Balugu and then Professor James Sefa. He thought, or he argued, that these persons were sued in their individual capacities. So the Attorney General did not have a role to play in representing them in Parliament. So they ought to have come with their own lawyers. However, there was a conversation with the bench where the bench asked him that, for instance, the justices were doing their job as justice of the Supreme Court. The president nominated them to be on a committee. It was not by their own doing that they got into the committee for which they have now been made parties to this suit. So to argue that they have been sued individually for which they needed to have their own lawyers was an argument they could not subscribe to. In fact, they even indicated that if, for instance, so in this particular matter, they did not agree with the former Attorney General that these people needed to have their own individual. What they said was that they were performing a public function, for which they also deserved the service of the Attorney General. In fact, he did not push it further when the bench urged on him to rest his objection.
His argument on that.
So they let that.
I'm going to come back to you because I want to learn whether or not, the argument about Justice Bawumia having, sat on cases involving, two of the petitioners also. I want you to dig down on that and how it played or did not play out in court today. But let's take a listen to former Attorney General Godfred Dame. Like I said before, he had misgivings about the outcome of the Supreme Court hearings today. Take a listen.
Was not pleased with the outcome.
I'm quite surprised that the Supreme Court will be more or less acceding to the expectation of such violations against the highest judicial official. The issues are far-reaching and they actually hinge on matters which affect the independence of Ghana's judiciary, the security of tenure of judges and all. But if the Supreme Court, for whatever reasons, does not seem to take that view, well, so be it. I think that in future, the whole nation will get to know.
He maintained that the suspended Chief Justice will continue to assert her rights.
She knows what is due process. She knows what is constitutional rights. And I think that's what she's asking for. And how can it be correct that a judge who sat on two matters, of which she also sat, be called as witness in a petition against her, and that same judge be made the chairman of the committee that is supposed to inquire into the petitions against the Chief Justice.
Godfred Dame is former Attorney General of the Republic of Ghana. Dennis Wedam is still here with me. Dennis, that concluding remark he made is just about what I was talking about before we took the video clip, right? Did that come up in court today?
Yes, it did. So that was one of the main things that was argued in respect of the main injunction application. And the former Attorney General, I still refer to him as Attorney General for some reason. I mean, it will take some time to go, but yes, the former Attorney General, he made the argument that the two justices, Justice Gabriel Bawumia and Justice Samuel Seidu, should not be part of the committee. His reason for Justice Gabriel Bawumia is the fact that he had given judgments which went in favor of one of the petitioners, Daniel Ofori, in this particular matter. The bench asked him if it was just the issue of giving judgments that went in favor, and that if they, as justices, had given judgments that went in favor of some other individuals, does that mean that when they meet them again in other fora, they cannot? So he explained that it's not just about giving the judgment, but that judgment has now become a subject of the petition itself. And that was the basis for his objection. But yes, they still went on to prove further that if, for instance, they, as justices, so at this point, Justice Yoni Kolendi was the one doing the questioning, together with the president, Justice Paul Bafoboni, that if they, as justices, for instance, they give judgments in favor of somebody, and then again, they are promoted. He even used the example of promotion of justices from the lower courts to the higher courts, where they go to meet decisions that they had made at the lower courts, for instance, and then they are supposed to sit on it. Should that be basis for them to recuse themselves or not be a part of it? Then, in fact, they even did indicate that that particular judgment they are talking about, that's the claim, or they say that Justice Bawumia gave judgment which went in favor of Daniel Ofori. Justice Yoni Kolendi and then the president, Paul Bafoboni, were part of it. So they asked the former Attorney General that, so they do not qualify to be part of the committee. He said, no, he said, under the circumstances, no.
I mean, so essentially they got him to admit. Not to admit, but he still stood his grounds. He was forceful about his argument that for the fact that that judgment has now become the subject of the petition, if they too were also part of it, then the argument still applies to them too. Yes. So he was forceful in argument. For Justice Samuel Seidu, the argument is one that has been repeated. And I say repeated because it has come up before. The argument simply is that when Vincent Esefwa first filed his injunction application,
The first panel that was constituted, he was part of it. However, the court could not sit. It was adjourned twice. By the first adjournment, he was appointed to be part of the committee. The Attorney General's argument is that this is a man who was part of a panel that was supposed to look at a matter that affects the issues we are talking about. So he should not be a part of it.
And that's Godfrey Dame's argument, right?
However, I mean, because the full ruling of the court is not out yet, you are unable to tell the reasoning behind that. But what is obvious is that at the end of it, I mean, together with the opposed argument from the Attorney General or Deputy Attorney General who was in court today, the court came to the conclusion that, no, we are not persuaded by your application. It is without any merit. On that basis, we are dismissing it. This time around, it was a unanimous decision, all 5 justices. And if you don't mind, yes, this is the panel for today.
I see. And you know, I can't wait to read the reasons for the decisions that have been taken today. Again, remember that yesterday when we spoke about this, I had indicated that for the 3-2 decision in the Vincent's case, one of the elements or criteria that they had pegged, you know, the decision whether or not to agree to an injunction of the process was the inability of the applicant to show that whatever was going on will have a direct impact on him. And I'd like to see what the argument will be in this case, whether or not it applies at all. Because, I mean, the ruling was very emphatic that based on previous rulings or precedents, you needed to, you know, in order for that injunction to be given, it needed to be able to meet certain requirements. And one of those requirements was that.
Precisely so. Yes. And just to add that was the beginning point of the Attorney General, Deputy Attorney General, who was in court making his arguments in opposing this application, to say that the court itself has, even before today, given decisions dismissing such interlocutory applications. He goes back to cite parts of their own judgment in the Vincent case to make the case that, look, I mean, we have been here before. A lot of these matters have been argued before. The court did not find them persuasive. Why are we doing this again, so to speak?
And it's usually a persuasive argument
before
when you
adding on
them
to the specifics that was on it. And eventually, I think he had his day on that. And, I mean...
Okay, Abusuya, aye majority leader and aye teninka ewo political highway so aye Chief Justice ne nneoma just ne petitions and say ne applications ne injunctions or they court say omon stop aye investigations probe no Abusuya aye majority leader Mahama Ayariga&NDC etutu bi mane na enye asem keto akra intino Chief Justice Torkonoo de wo hwe ba bia Parliament for Krampo ejinama enye izi kura bada masesa mo jepene kokoti sa audio we edemai aha POG Media so